process.
I call Julianne Genter.
In rising to speak on the bill this evening, I'd like to first comment on the supplementary order paper that I've put forward, which is Supplementary Order Paper 173. And this would amend the Taxation, Transformation, First Phase, Simplification and Other Measures Bill, which fundamentally amends the Income Tax Act. And the purpose of my supplementary order paper is to improve the disclosure around New Zealand foreign trusts. We didn't consider this issue at length in the Select Committee, and of course the reason for that is because IRD never did continue their review that they intended to undertake back in 2014 around the disclosure regime for New Zealand foreign trusts. They had intended to undertake a review because we were attracting criticism, because there was the possibility that people offshore were using New Zealand foreign trusts as a way to avoid paying tax in their home country and perhaps more nefarious purposes. But of course, as we've come to know in the recent weeks, the national government was lobbied directly by people who are very active in the New Zealand foreign trust industry, some of whom were very close to the Prime Minister, some of whom are directors of an astonishing number of companies. We have here the Cone-Marshall, directors of around 1,000 companies, look-through companies. And of course, they lobbied the national government, who then decided to give the message to the Inland Revenue Department that we shouldn't continue the review of the New Zealand foreign trust regime. And so we're left here with a situation, because the Mossack Fonseca leak has pointed to the role of tax evasion and avoidance globally, the terrible problem that it's playing in increasing wealth inequality around the globe. Of course, tax havens serve no useful economic purpose. They don't further the goal of a more prosperous and fair economy for all people. And that's something the Green Party holds very, very dear. We want to have a fair and prosperous economy. And we don't want New Zealand to be playing the role that it has been playing. Simply, very simply, we think that it's perfectly reasonable and sensible idea to have the Inland Revenue Department collect information on the people who are setting up New Zealand foreign trusts so that they cannot be used for tax evasion, avoidance, or any other nefarious purpose. We just want full disclosure. And I think that's something that the national government, really, I can't understand why they wouldn't want full disclosure. It doesn't cost anything. It simply means that our New Zealand foreign trust regime can't be abused by people who are seeking to break the law or do things that are wrong. And although the Prime Minister started talking about this issue when it first broke, saying that New Zealand already had full disclosure with respect to New Zealand foreign trusts, of course, it turned out that wasn't true, and many tax experts and academics pointed this out. I have a paper here from Michael Littlewood from the University of Auckland. Anyone can go look it up online. He's a tax expert.
I'm sorry to interrupt the member. I've looked at this closely, to the member, and this is actually outside the scope of the bill. And one must, because we're in the committee stage here, we must focus on part one of the bill. And I've sought advice, and if we look at Speaker's Rulings 132.1, it's covered there. That amendments that are outside the scope of the bill do not widen the scope of the debate of the bill. And so, unfortunately, I'm going to have to rule it out. If the member wants to continue, I'm not going to cut your time off, but in terms of the SOP specifically that you are actually referring to in the foreign trust part of that, then that's out of scope of the bill. So the member can continue, and but keep it within the bill as part one actually identifies.
Point of order.
Oh, well, no, before, you had a point of order. Julianne Genter, point of order.
Point of order. Mr. Chair, I'm just seeking your clarification because my understanding is the supplementary order paper was accepted and it wasn't ruled out of scope. So I'm unclear how it is that you're able to now rule it out of scope.
Right here. Yeah. I'm just going to seek some advice on this, because while an SOP can be tabled on the table, then it becomes evident whether it's in or outside the scope of the bill. My understanding is, and I am seeking advice, is that if it's outside the scope, it can't be ruled out until it's tabled, and that's why it has been tabled. You've got a number on it, an SOP number on it, and I'm seeking advice now, but I'm advised that because it's outside the scope of the bill, you can't actually refer to it in the context that you are. You can refer to part one, of course that's the part that we're on, but in terms specifically of your SOP and foreign trusts, that's what's out of the scope and out of order. I'm just seeking advice, however. Yeah, if you just don't mind waiting, I'm just seeking advice.
So there's different issues. One is about whether it's in the scope or not. It's not a negotiation. It's a decision of the chair. Or that's the advice. So the question now is about
All right, I have, to the member, I have sought advice, and the ruling that I've made stands. While you've tabled the amendment, and that's fine to table the SOP that you have, until you actually start speaking to it, one doesn't know what you're actually going to be saying. And it wasn't until the debate had started, and I did seek advice before I intervened, and the ruling is the ruling of the chair that it's outside the scope and it's out of order. And so from the member's point of view, if you wish to continue, still have time available, you need to come back onto the scope of the bill, which is part one. Grant Robertson, point of order.
Mr. Chair, I just want to ask a couple of questions about your ruling, because I would have thought it was normal practice when the decision is made to rule out an amendment. Either it is at the point at which a person has, attempts to table. This is not a handwritten amendment. This is an amendment that's been tabled. It has a number. It's been accepted. So that's the first hurdle, is that it has to be accepted, and that's occurred. It is then, as my understanding, normal practice that when we come to the vote on the amendment, that would be the stage at which you may or may not decide that it remains relevant to the bill, rather than you making a ruling actually in the middle of someone's speech, but when it's been debated. I mean, I had intended, Mr. Chair, to give a speech, and I would have thought you might hear some calls, and that would be what would help you decide when we came to a vote as to whether or not it was in order.
Yeah, well, I thank the member for those comments. They are helpful. While an SOP can be tabled, and the clerk's office has allowed it to be tabled, until a debate on it actually happens, one doesn't know what the points of debate are going to be. And it's only once the debate has started, and that's why I did allow it to carry on longer than possibly, in reference to what you're saying, is that I did allow it to happen to see what the content of the debate was going to be. And on that basis, once the member got into the discussion in a substantive part of what the debate was about and referred to the SOP and the foreign trusts, it's at that stage that I intervened and said it was out of scope of the bill and now out of order. Stuart Nash, point of order.
Sorry, Mr. Chair, I'm just seeking your guidance on actually when will we be able to debate the SOP? There are some clauses in the bill that do talk about foreign investment funds, and so there could be some relation to that, or there's parts in the bill that talk about listing on the Australian Stock Exchange, and so there are, I mean, well, I suppose my question is, at any point in time during the committee stage, will we be allowed to debate Julianne Genter's SOP at all?
Yeah, well, it's the chairperson at the time who makes that deliberation. I've ruled this SOP's out of order and out of context. If the member wishes in the course of the debate to talk about the points that you mentioned, the presiding officer at the time will make that determination. I've said that this SOP is out of order because it's out of scope, and that's the end of the matter. Now, I'm inviting Julianne Genter to continue with the time available if you wish to continue on part one.
Thank you, Mr. Chair. The purpose of this bill is to simplify and improve the administration of the tax system. And so it makes a number of minor amendments to a variety of acts, including the Income Tax Act 2007. I take it that I'm allowed to at least say what my SOP would have done, which was amend Section 59B of the Income Tax Act, which currently only requires the name or potentially just the date of settlement on the trust that relates to a foreign trust, which is clearly not full disclosure. And I'm sorry to say that the national government won't even allow us to debate this in the House, even though it would have been a perfectly relevant amendment, simple amendment to the Income Tax Act that would have simplified greatly our tax system and provided a whole lot more disclosure on an issue that is of great importance to New Zealanders and indeed people all over the world.
Call Grant Robertson.
Chair,